Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. The court reviewed the history of airports regulation in India and analyzed the provisions of TRAI Act, including the 2003 amendment. The court concluded that the development fees collected under Section 22A were statutory exactions, not fees or tariffs. The court emphasized that these fees were not charged for service or facilities provided by the Airports Authority. The Airports Authority of India Major Ports Development Fees Rules 2011 authorized the collection of development fees and introduced an escrow account system for depositing the fees. The utilization of the fees had to be approved by the AAI. The court noted that the development fees collected were made for specific purposes mentioned in the TRAI Act and were used to bridge the funding gap for future projects at airports. The Supreme Court has reiterated the legislative intent regarding the interpretation of Section 3.1.10 of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act and clarified that the intent of the legislature is clear in the distinguishing between general insults or intimidation and those specifically aimed at individuals due to their caste or tribal identity. Dealing with the criminal appeal, a division bench of Justice Dipankar Datta and Justice S. Ravindra Bhatt concluded that even if the appellant did insult or humiliate the complainant with caste-related abuses, it does not substantiate the complainant's case under the Section 3.1.10 of the SC/ST Act. The first FIR and the charge sheet make no reference to the specific words uttered by the appellant during the verbal altercations or the complainant's case except for the general allegations of caste-related abuses. The legislative intent is clear that mere insult or intimidation of a person is not sufficient to constitute an offence under Section 3.1.10 of the SC/ST Act unless it is specifically targeted at the victim due to their belonging to a particular scheduled caste or tribe. Therefore, the charge sheet does not establish a case for the appellant's offence under Section 3.1.10 of the SC/ST Act, and it is essential that the specific utterances made by the appellant in a public place be outlined in the charge sheet to ascertain the viability of the offence. The Supreme Court in the case of National Insurance Company Limited versus Vedic Resorts and Hotel Private Limited has held that wherever such an exclusionary clause is included in a policy, it would be for the insurer to show that the case falls within the purview of such clause. The court interpreted the clause 5th by stating that the loss of visible physical damage or destruction caused to the insured property by external violent means was covered, but the loss, damage or destruction caused to the property by burglary, housebreaking, theft, larceny or any such attempt or omission of any kind by any person in any malicious act was not covered. It was also stated that if the insurance company claims that the loss and damage was not caused by any malicious act, the insured bears the burden of proving the contrary. It was observed that it is hardly any evidence that the respondent complains malicious actions were the cause of the entire incident and resulting in the damage of the insured property. It was furthermore observed that it is the right to the state to state that whenever a policy contains an exclusionary clause of this kind, the insurer must demonstrate that the situation is covered by the clause in question. In case of uncertainty, the insurance contract must be interpreted to the insured's benefit. The Supreme Court has observed that the accusation of corruption in electoral proceedings holds significant weight as quasi-criminal offences and emphasized that it is important to ensure that accused candidates are properly informed about the specific allegation made against them. The division bench of Justice Abhay Oka and Justice Rajesh Bindal opined that the accusation of corruption, as defined by Section 123 of the Representation of the People's Act 1951, encompasses a range of unlawful practices directly linked to the electoral process. In the appeals emerged from an election petition under Section 81 of the Representation of the People's Act, the appellant has contended that the election petition lacks a cause of action in support of the corrupt practice allegation. He highlighted the requirements outlined in Clause A and B of the subsection 1 of Section 83 of the RP Act of 1951 and submitted that these clauses stipulate that election petition must include a concise statement of material facts and complete particulars of the alleged corrupt practice committed by winning candidates. It also emphasized that the Clause B of the subsection 1 of the Section 83 also necessitates the election petitioner to provide a comprehensive statement disclosing the names of the parties accused of engaging in such corrupt practices, along with the date and place of their occurrence. providing a detailed explanation to the nuances surrounding Section 156(3) and Section 202 of the Criminal Procedure Code. The Supreme Court shed light on the powers of the magistrate during the pre- and post-cognizance stages and stressed that the role of the magistrate in determining whether to issue directions under Section 156(3) or follow the procedure under Section 202. The division bench of Justice M.R. Shah and Justice Sanjeev Khanna referred to the dictum in Gopal Das Sindhi and others versus State of Assam and others, wherein the Supreme Court expounded that when a private complaint is filed, the magistrate has the discretion to either take cognizance under Section 190 or direct a police investigation under Section 156(3) of CrPC. If the magistrate opt to proceed under Section 156(3), the magistrate cannot simply dismiss the complaint but should consider alternative procedures such as examining the complainant on oath and conducting further investigation under Section 202. The High Court's decision in remand the matter to the judicial magistrate for further examination was deemed appropriate. The accused was the right to appear before the revisionary court when the complaint challenges the rejection of the application under Section 156(3). The documents submitted by the accused before the High Court and Supreme Court should be forwarded to the magistrate for examination. Additionally, the complainant has the right to question the genuineness and contents of those documents. Next, we have Delhi High Court. The Delhi High Court, in the case of Vodafone Mobile Services Limited and others versus Telecom Regulatory Authority of India, while upholding the penalty on Vodafone, held that when there is a specialized tribunal, the Telecom Disputes Settlement and Appellate Tribunal constituted to deal with the disputes under the TRAI Act, then courts must be slow to interfere under Article 226 of the Constitution of India. The division bench of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad was adjudicating on the issue related to the authority of the TRAI to suggest penalties under Section 11 of the TRAI Act. Relying on Union of India was an association of United Telecom Services Provider of India, the bench concurred with the contention of the respondent that the first proviso of Section 11(1) states that the central government is not obligated to follow the recommendation of certain authorities listed in Clause A of subsection 1. The government reviews recommendation and only send them back for reconsideration if they cannot be accepted or need to be modified. Relying on Cellular Operation Association of India versus Union of India, it opined that the tribunal's jurisdiction under Section 14 cannot be considered as supervisory as it is only forum for resolving grievances and the appellate jurisdiction is limited to substantial question of law. Civil court jurisdiction is also excluded. The tribunal has the power to settle any dispute, but it must consider the recommendation of TRAI. Moreover, as per MS South India Bank Limited and others versus Naveen Matthew Philip and others, if a specific tribunal has been established to handle disputes related to the TRAI Act, courts should refrain from intervening too quickly under Article 226 of the Indian Constitution. The Delhi High Court has held that the right of the daughter-in-law in a shared household is not an indefeasible right and cannot be to the exclusion of the in-laws. The court reiterated that in the case of Satish Chandra Ahuja versus Sneha Ahuja, the Supreme Court has ruled that the right to live in a shared household under Section 19 is not absolute, particularly when it pits a daughter-in-law against elderly parents-in-law. The court emphasized that senior citizens have the right to live peacefully without being affected by the marital discord between their children and in-laws. It opined that the concept of a shared household means that a daughter-in-law does not have an absolute right to live in the household without the in-laws. The idea that in-laws should not be allowed to live in their own property is incorrect. If a daughter-in-law claims that the right to live in the shared household, she cannot argue that the in-laws should not live there too. If it is impossible for them to live together, the daughter-in-law may need to find alternate accommodation. The Delhi High Court has held that in matters when the court is dealing with the petitions pertaining to family law where the parties are already at loggerheads with each other, even though the matters are required to be decided expeditiously, the court is expected not to adopt such a hyper-technical approach and close the right of the parties to cross-examine in such a hurried manner. The bench stated that although the petitioner's behavior in court was not appreciated, it was only on one occasion that they failed to cross-examine a crucial witness. Even if the petitioner's excuse for not receiving evidence or being busy with another case is not accepted, the court should have considered the grave harm caused by denying the right to cross-examine. It further opined that when the court deals with the family law cases where the parties are already in conflict, they should not rush to close the right of the parties to cross-examine by taking a hyper-technical approach, even if the case needed to be resolved quickly. The Delhi High Court has allowed the petition filed by a Korean national, Daeyoung Jung, seeking permission for his enrollment as an advocate in India. A single-judge bench of Justice Yashwant Verma observed that foreign nationals can be enrolled as an advocate in India if citizens of India are allowed to practice law in their country. The court clarified that Advocates Act 1961 does not completely oust foreign nationals from consideration for enrollment, as the proviso to Section 24(1)A of the Advocates Act creates an exception for foreigners who may file for enrollment. It was held that in the absence of nationality restrictions clause in a foreign nation, their citizens would be entitled to apply for the enrollment subject to their being compliant with the other parts of Section 24. Jung, a lawyer who completed his law study in India and at first approached the Bar Council of Delhi, was restrained from enrolling. Now let's have an overview of other high courts. The primary purpose for adoption under the JJ Act is rehabilitation of the children who are orphans, abandoned or surrendered in terms of prescription as laid down. That apart, stringent guidelines for adoption have been framed. Adoption is carried out through the Central Adoption Resource Agencies, followed by the procedure as laid down under subsection 5 of section 41 of the Code, the Court said. The Court added that under section 3 of the said Act, provision has been made to make a declaration, one, that any person who satisfied the prescribed authority that he is a Muslim and that he is competent to contract within the meaning of section 11 of the Indian Contract Act, and he is a resident of the territories to which this act extends, may be the declaration in the prescribed form and filed before the prescribed authority to declare that he desires to obtain the benefit of the provision of this section. And thereafter the provisions of section 2 shall apply to the declaration and all his minor children and their descendants, if in addition to the matter enumerated therein adoption, wills and legacies were also specified. The court noted that no document has been produced with the counter affidavit by the respondent to show that the petitioner and his wife were issued the notice from the court or they have appeared in the proceeding. Mere institutions of the civil legal actions does not mean that the respondents in opposite parties are in the know of such institutions. The Gujarat High Court has observed that the courts can allow evidence on affidavit in its discretion, and while considering the aims and objectives of the Domestic Violence Act, including the scope of Section 28(2), the court can deviate from the procedure mentioned under subsection 1 of the Section 28, read with Rules 6(5) and devise its procedure, which would include permitting evidence by way of affidavit. Further, the court remarked that the Act of 2005 is to provide for effective protection of rights of the women who are victims of violence of any kind occurring within the family. The preamble also makes it clear that the reach of the Act is that violence, whether physical, sexual, verbal, emotional or economic, is all to be redressed by the statute. The Bombay High Court has analysed the provisions of the Railways Act 1989 to assess as to whether the claimant were entitled to compensation by the Railways Administration for an accident failing for a passenger resulting in his demise. The division bench of Justice Urmila and Justice Joshi Phalke construed the provision in a liberal manner as the objective of the Act was meant to benefit society at large. The major contention of the railway that the passenger is not entitled to compensation because no railway ticket was found on the body was rejected. The court held that it is very well possible that during the incident the ticket was lost. The court firstly pursued the definition of an untoward incident and as per section 123C of the Railways Act 1989 to assess whether the death of the deceased is covered under untoward incident. The court, after analysing the evidence at hand, held that merely because the ticket was not found on the body of the deceased, it is not sufficient to infer that he was travelling without the ticket. Reliance was placed on the decision of Union of India versus Reena Devi, wherein it was held that the initial onus to prove death or injury to a bona fide passenger is always on the claimant. However, such an onus can be shifted to the railways if an affidavit of relevant fact is filed by the claimant. It was further held that the injured of the deceased was the bona fide passenger for which the claims of the compensation could be maintained even if the ticket was not found along with it. The mere absence of a ticket with such an injured or deceased will not negate the claim that he was a bona fide passenger. The initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and the burden will then shift to the railways, and then the issue can be decided on the facts shown on the attending circumstances. The Allahabad High Court, while granting anticipatory bail for the cases registered under Section 498A, 304B IPC and Section 3 and 4 of the Dowry Prohibition Act, has observed that the provision of the anticipatory bail was inserted to save litigants from false prosecution, and it cannot permit the prosecution to be converted into an area to settle score. The court, after hearing the rival contention and going through the record, observed that considering the nature of the accusation and antecedents of the applicant, where there was no complaint against the applicant or his family members before the death of the deceased person, and also that no visible injury has been observed on the body of the deceased person, internally or externally, therefore, in view of the court, the applicant is liable to be enlarged on anticipatory bail in view of the judgment of the Supreme Court in the case of Sushila Agarwal versus State of NCT of Delhi. In respect of Section 438 CrPC, the court observed that it was inserted into the code as it has been seen that the influential person tried to complicate their rivals in false cases for the purpose of disgracing them by detaining them in jail for some time. The prosecution cannot be permitted to be converted into an area to settle scores. Setting aside the trial court's order dismissing an application filed by a woman for clubbing two pending suits for a common trial and disposal, the Karnataka High Court has remarked that the discretion of the court to transfer or club cases isn't in line with some Mughal emperor. The single judge bench of Justice Krishna S. Dikshit quoted Lord Hillsbury from a century-old judgment in Sharp versus Wakefield and stressed that the discretion means according to the rules and reasons and justice. The writ petition was filed by a wife assailing the order whereby the family court had refused to club two pending suits for a common trial and disposal. The suits filed by her and her ex-husband relate to some property, and thus the counsel has argued that when the matter essentially relates to the same property, then the list is between the ex-spouses. The grant of the subject application was eminently warranted. The court agreed and observed that when parties are the same, property involved is the same, and the court in which the suits are brought is also the same, ordinarily the request of clubbing should not be denied, subject to all just exceptions. Moving on to miscellaneous news. Backing for the continuance of the sedition law in the system, the Law Commission of India has said that the Section 124A of the Indian Penal Code needs to be retained due to the internal security threats and to prevent the offences against the state. However, certain amendments may be introduced in the provisions. The Commission, in its report to the Law Ministry, stated that the threat exists to India's internal security and that freedom of citizens can be ensured only when the security of the state is ensured. It further stated that social media has a proliferating role in propagating radicalization against India and bringing the government into hatred, many a time the initiation and facilitation of foreign powers. This is all the more required that the Section 124A be in place. Calling sedition reasonable restriction under Article 19(2), the Law Commission pointed out that the Supreme Court, while dealing with the constitutionality of Section 124A, held that the law was constitutional as the restriction is sought to be imposed was a reasonable restriction. The Delhi High Court has reserved judgment on June 1st in a batch of petitions filed by lessors of the financially troubled airlines Go First seeking deregistration of their aircraft. The Director General of Civil Aviation, against whom the plea was filed, argued that they had not rejected any lessor's application for repossession due to a moratorium. The DGCA further stated that they neither support the lessors nor Go First in the dispute but are obligated to follow the court's order. According to the DGCA, it takes 5 working days to process repossession application, and since the applications were submitted on May 4th, they could not process them before the National Company Law Tribunal admitted the airline to insolvency on May 10th due to 3 public holidays in between. A Delhi court has criticized the Delhi police for serving summons on public witnesses only through WhatsApp and referred the matter to the Deputy Commissioner of Police for appropriate action. Additional Session Judge Hemraj was hearing a murder case registered by the Punjabi Bagh police station, which was at the stage of prosecution evidence. The court said that while the head constable concerned made no efforts to serve the summons, the inspector concerned forwarded the report regarding the summons which showed lackadaisical application of mind. It then directed a copy of the order along with the letter received earlier to be sent to DCP West for pursual and appropriate action. The court also issued a notice to the police officials concerned for their personal appearance to give an explanation as to why appropriate action be not taken against them under the provisions of the Delhi Police Act and the Indian Penal Code. Uttarakhand High Court has issued a notice in a PIL filed against the permissibility under the Muslim personal law to marry off girls below the age of 18 years. The Division Bench of Chief Justice Vipin Sanghvi and Justice Alok Kumar Verma implemented the issue notice to the All India Muslim Personal Law Board and has sought a response within 4 weeks. The petitioner, Youth Bar Association of India, has sought directions to the government to formulate a standard operating procedure for ensuring that girls below 18 years of age may not be permitted to marry irrespective of their religion, customs and local or personal laws in the larger public interest. The practice of allowing young girls of age below 15 years to marry under Muslim personal law has been highlighted. It has been argued that permitting teenage girls to marry violate their basic rights to live with dignity, education, health and protection which are guaranteed by the Article 21 of the Constitution of India. It was further averred that this not only ends the childhood but also equally detrimental to the society. Throwing a woman out of a jointly owned property amounts to domestic violence, observed a magistrate's court and ruled in favor of the woman. It directed her brother and sister-in-law not to remove her from their home. The victim, who had moved back to her parents' home after her divorce 23 years ago, told the court after the marriage of her brother in 2016, his wife began to physically assault her and repeatedly threw her out of the home. In the end, we have international news. Artificial intelligence tools ChatGPT has been making headlines since its debut. It has been used to complete assignments such as writing emails in specific tones, styles and instructions. In a bizarre incident, a lawyer from New York is facing a court hearing after his company, Levidow and Oberman, used the AI tool for legal research. This comes to light after filing used hypothetical legal cases as examples. Noticing the same, the judge remarked that the situation left the court with an unprecedented circumstance. However, the attorney said in court that he was unaware that its content could be false. Pakistan's Interior Minister Rana Sanahullah has said that Imran Khan will be tried in a military court as the former Prime Minister was the architect of the May 9th incident in which military and state installations were attacked by his party workers following his arrest in a corruption case. Sanahullah also accused the 70-year-old chief of the Pakistan Tehreek-e-Insaf party for personally carrying out the planning of the attacks on military installations before his arrest on the day. The US House of Representatives has voted to raise the federal debt limit just 5 days ahead of the deadline set by the Treasury. The debt ceiling agreement negotiated between President Joe Biden and House Speaker Kevin McCarthy put Congress on track to approve additional borrowing just days before the government is anticipated to run out of the money. Majorities in both the parties supported the agreement, which also satisfies the GOP demand to reduce non-defense discretionary spending over the next 2 years, and the package passed by a vote of 314 to 117. FIFA had recently passed yet another regulatory scheme to reduce the amount of money agents can make, limit the role they can play and service they can provide, and control how they can charge for them. This system, formerly called the FIFA Football Agents Regulation or FFAR, has been now put on hold in Germany. A Mainz District Court judge had initially referred the question of whether the new regulation were an illegal restraint of trade to the European Court of Justice for adjudication. Now, another judge in Dortmund has ruled that due to the length of the time it will take for the ECJ to hear the case and the pressing economic interest at stake, that while waiting for the fuller ruling, the DFB will be prohibited from enforcing FFAR in Germany. This decision has run contrary to the earlier two decisions in the Netherlands, which allowed the system to stand. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.